Welcome back again to Bankruptcy with Ben. I want to take a quick break from many of the large retail companies that we've been following. An interesting news story I came across. Something unusual does not happen too often, and it caught my attention. Now, we don't generally follow criminal law on this channel. The world of bankruptcy is mostly civil. But there are times when, despite the fact that it's a civil proceeding, you could still be charged criminally, and even when you're not charged criminally, a judge, in some instances, can even throw somebody in jail who has not otherwise been charged with a crime. And that brings us to the story of a major real estate developer. And this story comes courtesy of Houston Real Estate News from BizNow. It says, judge issues an arrest warrant for Houston real estate investor Ali Chowdhury. United States bankruptcy judge Jeffrey Norman has issued an arrest warrant, meaning he's going to jail, for Houston office landlord and investor Ali Chowdhury for contempt of court, according to a Wednesday court filing. So what happened here, and how does somebody who is presumably a well-to-do businessman, not charged with any crime, suddenly find himself facing jail time? So the short answer is he pissed off a federal judge. It's a big no-no. Judges, especially federal judges, have a lot of power. If a judge issues an order, you have to cooperate. And if you don't cooperate, you can end up in the slammer. So Norman demanded the U.S. Marshal Services arrest Chowdhury, the founder and CEO of Jet Alcos. Why? Because he did not produce court-ordered documents, according to the warrant. The order was made in the case regarding a Chapter 7 bankruptcy of Jet Alcos. So Jet Alcos is the company that filed for bankruptcy. Well, actually, let's take a step back. To be more specific, Jet Alcos is the company that is in bankruptcy. They did not file for bankruptcy, as we'll see. Jet Alcos is owned by Ali Chowdhury. How do they end up in bankruptcy? Another very interesting point, which does not happen too often. There was an involuntary petition against Jet Al filed on December 4th by a company that claimed it was owed about $100,000 for consulting services, according to court filings. Keep in mind, in the world of high-end bankruptcy, especially in the world that I deal with, which in my world is not even the higher end of things, it's, I'm dealing with smaller, mid-level market companies, often involving real estate. But $100,000 is a fairly small amount of money. Usually, even the lower ends of the spectrum, you're dealing with several millions of dollars worth of debt, of real estate holdings, things of that nature. Especially where I practice in New York City, every real estate, even just a single home, is worth $1 million. So $100,000 being owed is a very small amount of money. And in particular, it's a very small amount of money to have to go to jail for. But this company was owed $100,000, and they decided, we're going to turn the screws and put pressure on this guy. He's not paying us. We're going to actually file bankruptcy against him. He doesn't want to do it. Well, not him, his company. We're going to take the company and, against their will, put them into bankruptcy. And what does that accomplish? So many times creditors do not like bankruptcy because they're stopped from suing them outside of bankruptcy court. They're stopped from trying to collect assets and putting a lien on things and trying to collect on their judgment. But the nice thing about bankruptcy, especially if you're a creditor, is there's a lot of powerful tools. And you have a federal judge who's overseeing a very transparent process. And you have a trustee. A trustee is someone appointed by the courts who has the power to independently examine all the books and records of a company and look for any kind of irregularities. And in the event that he finds something that's improper, he can actually start lawsuits against recipients of money transfers that should not have received the money. So, for example, if Mr. Chattery raided the company and took $500,000 wrongfully out of the company and used it to buy a yacht for himself, well, a trustee can go in and sue Mr. Chattery and force him to now go ahead and bring that money back and repay it to creditors. So it's another tool that creditors can use to exert more pressure on people or companies that owe them money. Now, this guy, Mr. Chattery, does not have a good reputation. The same judge previously called Mr. Chattery a forger and a liar in a separate bankruptcy case last year. So we don't know yet all the details, and that's not really what I want to get into right now. The point is, he does not have a good reputation, and we do not have a good reputation, and now he pissed the judge off even more by not cooperating with what the judge ordered. Not a good look, and now he finds himself in jail. Now the article goes on and it says all the other kind of things that Mr. Chattery did are wrong. And the arrest warrant, Judge Norman said, the court is only left with one remedy to compel his compliance. And he's expected to self-report by 9 a.m. Thursday, though the warrant says the marshals are authorized to use any force reasonably necessary to take Ali Chattery into custody. Okay. It's pretty wild. I've never seen a judge actually arrest someone. I have seen on occasion, once or twice, a judge make some threats when compliance is not forthcoming. It's very rare. The bottom line is, if you're in a court proceeding, even if you're not charged with a crime, there is the matter of contempt of court. A judge says you have to do something, you're required to listen to the judge. It's now the law as it relates to you. And if you don't, the judge has the power to put you in jail until you cooperate. Now, just remember, this is civil contempt, not criminal contempt. So civil contempt, you can purge it by cooperating. So the second that he cooperates, you're free to go. Out of jail, no sentence, nothing like that. If he was charged with a crime, then it's a whole sentencing process. He has to get sentenced, and you can't just get out of jail by doing one nice little thing. Cautionary tale, it's really wild. I've never seen anyone actually get arrested for it. Be careful. You don't want to mess around, not with a federal judge, not with anybody, certainly not in the bankruptcy process. It also doesn't make you look good. Makes everyone even more suspicious of you. When you don't cooperate, it looks like you have something to hide. The best thing you can do is cooperate. Now, if you're not sure about what to do, you receive a lot of information. You receive a subpoena telling you to produce all sorts of documents, and sometimes it can feel overwhelming. I don't even know where to begin. Hire a lawyer. Have a lawyer sift through it. He'll walk you through it, what you need to do to respond, how to cooperate, make sure you're in full compliance. That's all for today, guys. Just wanted to share that quick update. Hope you found it interesting and informative. Don't forget to like, comment, and subscribe, and we'll see you on the next one.